Good afternoon, everybody. Welcome to this afternoon's webinar on how to deal with the annual shutdown, the 2025 annual shutdown. For those of you who don't know me, I'm Gordon Angus, the Executive Director of the South African Engineers and Founders Association, and I'll be running you through everything that you need to know, hopefully, about the annual shutdown. Can you believe it? It's nearly the end of the year. So, you know, it's that time again. We've got to know how to deal with leave pay, leave enhancement pay, shifts, and all of those sorts of things. So I'm going to be running everybody through that this afternoon. You will see the presentation up on your screens. I would also like to invite you to, if you have questions, to pop them in the chat. It's not a very long presentation this afternoon, so I think we could probably keep questions and answers until the end. And then we'll have a bit of a questions and answers session. So if you do have a question, please pop it in the chat and we'll get to it perhaps towards the end. All right. Please forgive me if you see me glancing off to the side. It's because I've got two screens. I have to do that because otherwise I don't see my presentation or I don't see the platform. So please excuse me while we do that. All right. So let's kick off. As obviously, as we've said, we have to deal with the annual shutdown provisions. So all the employees going on leave, and obviously a million questions probably coming from your employees at the moment with regards to that. So there we go. So just a brief run through what we're going to be doing this afternoon. We'll start with a bit of an introduction, a little bit of history with why we are where we are at in terms of the main agreement and the non-extension of the main agreement. Many of you will know the reasons for that. We're constantly reporting on this, but we'll run through that. Then we'll look at the annual leave requirements at law. So we need to know about the main agreement, even though it hasn't been extended yet, but it's also necessary to know about the other legislation that is applicable with regards to leave pay, etc. We'll look at the annual shutdown provisions of the main agreement very, very quickly before moving into, I think, what probably most people will want to cover, which is calculating leave pay and leave enhancement pay, or the leave bonus, people call it, and then finally just a few sort of parting words on exemptions. So once again, please make use of the chat functionality. I see there's also a Q&A function there. You can make use of either of those. See, they've added now a Q&A section as well. Either of those will be fine. All right. So just by way of introduction, and many of you will know this, a settlement agreement was reached in the last round of wage negotiations in 2024 between some of the employer parties to the MEIBC and the trade unions. That was in May 2024. But although there's a commitment from the signatories to that agreement to request an extension from the minister to non-parties, this has not been done yet. The reason why it hasn't been done yet, as we've reported in many meetings and so on over the past months, is because the MEIBC hasn't got a membership verification certificate yet. It's something that every bargaining council has to get every year, and what they do is they count the numbers of the respective parties in terms of employee headcount. And when they know exactly how many employees are represented by the various parties, obviously the employer organizations on the employer side and the trade unions on the labor side, they then are issued by the Department of Labor with a certificate of representativeness. There's been a hold-up because the membership verification exercise that was previously conducted, the data that came from that or was collected in that process became corrupted, and there were duplications and there were all sorts of problems. So it had to be done all over again, and that is still in process. So we do believe that there will be a request made for the extension of the main agreement at some point, but it's very, very unlikely to be this year. Possibly the first quarter of next year, maybe just before the wage increase. We're not quite sure yet. So be that as it may, whenever it does get extended, we'll deal with that at that point in time. But at the moment, there is no extension of the main agreement. So obviously that impacts on a couple of things that we're going to be dealing with today. So when we look at annual leave, it's necessary, as I said, to look at the requirements of all of the law. So you need to consider what the BCEA says about leave. And the BCEA is obviously the Basic Conditions of Employment Act. And the Basic Conditions of Employment Act says that employees are entitled to 21 consecutive days. So consecutive days, or calendar days, if you will, obviously includes Saturdays and Sundays. Or you can accumulate leave under the Basic Conditions of Employment Act at a rate of 1 day for every 17 days worked. In fact, you can even accumulate leave per hour, 1 hour for every 17 hours worked. So that's why your payroll systems, for example, will show 1.25 days per month, because obviously a month on average is 22 days, so it's a little over 17 days, which is why it gives you 1.25 days. That's the same sort of ratio. Under the main agreement, it's worded slightly differently in that employees under the main agreement are entitled to 15 working days. Okay, working days. So that doesn't include weekends, obviously, and it also doesn't include the public holidays, which and obviously there's a few public holidays during the annual shutdown period. Or 20 working days. 20 working days is obviously what employees who have longer service will get in terms of the main agreement and their leave apportionment. Those employees with more than 4 completed years service are granted an extra week's leave, so they'll have 20 working days leave come the end of the year. You also need to give consideration to your contracts of employment. Many employers do make reference to contracts of employment. Many employers do make reference to leave and leave provisions, and sometimes even leave enhancement pay or bonuses in their contracts of employment, and that can have implications as well, particularly now with regards to paying out bonuses at the end of the year. And also there is, past precedent. Whatever has happened in the past, obviously your employees will become accustomed to and will expect the same process, the same procedure, and the same leave calculations, etc., to happen at the end of the year this year. So you must consider all of this stuff when dealing with the respective issues that you have to at your respective companies, because they have very, very real implications. So I just thought we'd run through very quickly. This is really not all that relevant because we're too close to the shutdown to actually be changing anything at this stage. But for interest's sake, perhaps, in terms of clause 16 of the main agreement, which deals with annual shutdown, it says that if you're a company that haven't been observing an annual shutdown and you want to start observing one, it's too late, obviously, for this year to start observing one. But perhaps you could introduce it in 2026, because you have to give the bargaining council 9 months advance notice. And obviously the same notice is displayed on a company notice board for your employees if you want to start observing an annual shutdown. Okay. The duration of the annual shutdown, if you are shutting down, must be long enough to allow, this is what the main agreement says under section 16, must be long enough to allow the employees to take 3 weeks leave extended by public holidays. Remember, I said that those 15 working days exclude public holidays. So the period of leave will actually be more than 15 working days if you include the public holidays that fall in that period. If you want to discontinue an annual shutdown, you need to give even longer notice. There you must give your employees and the bargaining council 12 months notice. If you discontinue an annual shutdown, it's quite a thing, because you might get a situation arising, depending when employees have joined the company, that they'll go nearly 2 years without any annual leave. So it's a very, very difficult thing to transition through. It's not very common, but if you are looking at doing that, please be aware that it's a lengthy notice period that is required. And the main agreement says that consent from the MEIBC must be obtained to initiate or discontinue the annual shutdown. But the reality is that they wouldn't deny you that consent. They would simply look and see whether you've met the requirements in terms of notice periods and so on. And obviously whether the employees agree and so on is important, but they wouldn't stand in your way if you do want to either start observing an annual shutdown or discontinuing one, as the case may be. But that being said, we're obviously way too close to the annual shutdown now to meet these deadlines and notice periods and so on. So whatever's going to happen in December will happen, which includes obviously the paying out of employees' leave pay. Now, this is regulated by Clause 12 in the main agreement, and it's obviously calculated on a 40-hour work week or on actual normal hours if you do have slightly different arrangements. But most companies will be working a 40-hour work week, 40 normal hours, that is. And so it's calculated on that. So employees qualify for 15 working days, 3 weeks annual leave. After they've completed, if you're a 5-day week operation, 234 shifts. I'm not sure if there's anybody on the call today or the webinar today who runs a 6-day operation. Very, very rare. So we'll probably just ignore the 6-day arrangements and focus on the 5-day week. But employees qualify for their annual leave after completing 234 shifts. How do we get to 234? Well, you take 365 days in a year, you subtract the 104 Saturdays and Sundays during the year, you subtract further the 15 days annual leave that employees qualify for, and 12 public holidays that fall in the year. And that will give you 234 shifts. So that number of shifts obviously will fluctuate from year to year. Some years you'll get slightly more, some years you'll get slightly less. I know that this year it's been calculated that there's been 235 shifts available to be worked because I think it was Women's Day or Heritage Day, I can't remember. One of them fell on a Saturday, and so it was lost, so to speak, in terms of being on a working day, and therefore one more shift was available this year than perhaps in past years. But on average, 234 shifts must be worked before an employee qualifies for annual leave. So it's very important to understand that the main agreement talks about employees going on leave after they've completed a full year's worth of shifts, or at least have had the opportunity to work 234 shifts before proceeding on leave. So the calculation that you'll use to calculate leave pay is at the bottom there, and I apologize for the poor quality of it, but when I made it so big on the slide, the quality was a little bit affected. But be that as it may, you take the employee's normal weekly wage rate, which excludes allowances, night shift allowance and so on, excuse me, multiply that by 3 weeks or 4 weeks if it's an employee who's got longer service, so more than 4 completed years service, that you'll multiply it by 4, and then you multiply that by the number of shifts that the employee has worked during the day, during the year, I beg your pardon, divided by 234. So it's very important to understand how this formula works. If you imagine that the employee is earning 1,000 Rand a week, just to keep the math simple, 1,000 Rand a week times 3 weeks is 3 weeks pay, or 3,000 Rand. Then you multiply that by the number of shifts that the employees work divided by 234. So let's assume that you're working out the leave pay for someone who's joined the company exactly halfway through the year. So half of 234 is 117. Okay, so if you're working out the leave pay for somebody who's joined halfway through the year and has 117 shifts, you don't change the 3-week part of the formula. Okay, it's still normal weekly wage rate, so it's, let's say, 1,000 Rand in my example, times 3 weeks is 3,000 Rand, or the equivalent of 3 weeks pay. And then you multiply that by 117 over 234. So 117 over 234 is obviously a half, and a half times 3,000 is 1,500, or 7.5 days leave. So you don't actually prorata anything in terms of the number of weeks. You still use that same formula. The prorating function of this calculation comes in with the shifts that are accumulated per employee. So obviously your employees' number of shifts that they've worked will probably differ. If employees have been absent without permission, for example, they'll lose a shift. And so you might have some that have more than others, and some that have less. All the employees that join during the year obviously will have less, and they will get paid out in that prorated fashion as I've demonstrated. All right, so that brings us then, obviously, if we're talking about calculating, excuse me, the number of shifts worked by your employees in the year, we'll need to know exactly when an employee qualifies for a shift and when one doesn't. So the main agreement, and again, this is under the leave pay clause, clause 12, says that an employee gets a shift Obviously, if they come and they work for the day, okay, they'll qualify for a shift. But when they are not at work, there are certain instances where they will still, despite not being at work, still qualify for a shift. And that's what I've got listed on this particular slide. So if the employee is absent due to sickness, supported by a medical certificate, okay? So it's important for your employees to understand that if they take a day's sick leave without bringing in a sick note, and they're entitled to do that as long as the day that as long as the period of absence is not more than 2 days, and it's not on a Monday or a Friday or the day before after a public holiday, and they can do that twice in an 8-week period. But they must understand that if they do access sick leave in that way, then they're not going to be granted a shift. In order to be granted a shift, you have to have a medical certificate. So from that perspective, your employees always should be bringing in medical certificates. And the employees qualify for up to 43 shifts. So they've got 30 days sick leave over a 3-year cycle, obviously, but 30 days sick leave due to them. If they produce a medical certificate for any one of those 30 days, they'll get a shift as well. But the shifts continue to accumulate for an additional 13 shifts for a 5-day week operation. Okay, why 13? That's just what has been negotiated. The unions obviously wanted more, employers didn't want to give, and so it was settled on 43 shifts. So the 30 for the 30-day allotment of sick leave plus an additional 13 that can be awarded in any given year. So by way of an example, you might have an employee, say, for example, gets quite severely ill during the year and takes off 50 days, for example. Okay, 30 days of that will be paid out as sick leave. 20 days will be unpaid from a company's perspective. They could always put in a claim with the sick pay fund, but from the company's perspective, the company would stop paying after 30 days. You would grant shifts for those 30 days, and you would continue, despite not paying the employee any more sick leave, you'd continue to pay out or grant the employee shifts up to a maximum of 43 for the year. Okay, and those count towards leave pay and leave enhancement pay. So the same number of shifts that you calculate for an employee that you're going to use for the leave pay formula, you use that same number for the leave enhancement pay formula, which is coming up in the next few slides. The employees who qualify for longer leave, the longer serving employees, they obviously qualify for an additional week's worth of shifts while they're still on leave, on annual leave. Okay, and the reason for that is just so that we don't have to have two different formulae, one for shorter serving employees and one for longer serving employees. The employees who take that extra week's leave get 5 shifts for those days. If there's been an injury on duty up to a maximum of 3 months, the employee will qualify for shifts during that period where they are off recovering from the injury on duty as well. If there's been a protected strike in terms of Section 64 of the Labour Relations Act. Now, Section 64 of the Labour Relations Act is the section that deals with collective bargaining, as opposed to Section 77. Section 77 strike action is socio-economic, not socio-political, socio-economic protest action. So if you have, for example, a COSATU, for example, arranging a march against e-tolls or something of that nature, or unemployment or whatever the case may be, and employees participate, they won't get a shift for that. However, if there's a wage negotiation going on and there's a strike associated with the wage negotiation, then the employees would be granted shifts for that period. Obviously, with this year, there was no wage negotiation, so this isn't a factor in this particular year. If you have shop stewards, if you have a trade union presence on your shop floor and you've got shop stewards, if those shop stewards go off on shop steward training, then they do qualify for shifts up to a maximum of 5 days per year in terms of their shifts counting towards leave pay and leave enhancement pay whilst they're off on that shop stewards training. Now, unfortunately, with the state of the economy being what it is, there's very often the need in the industry for companies to implement short time. So short time is obviously a period where the company reduces the amount of days per week or the amount of hours per day, or combination of the two, that employees work every week, and obviously they only get paid for the hours that they work. So if you are a company that has had to implement short time during this year, you might be wondering, well, how does this affect the employees' shifts? So how it works is up on this slide. During periods of short time, the days that the employees actually work obviously count as shifts, provided that where the employees are working 24 hours or more over a 3 or 4 day week, and employees on a 3-shift system working 3 or 4 shifts per week must be credited with full shifts during the first 3 months of that short time working arrangement. Thereafter, only the shifts that they work plus 1. Why plus 1? That's just what was negotiated. Okay, it's not necessarily very logical. If the employees have been working during that period of short time for less than 24 hours per week, then they will only get the shifts that they worked. Okay, so let's say, for example, you implemented short time where the guys are working 2 days a week. Okay, so 16 hours a week. They'll only get 2 shifts for every week that they were working on short time. If you implemented short time and you went to a 4-day week, for example, okay, and the employees are then working more than 24 hours, then they'll get full shifts for the first 3 months of the short time. Thereafter, only the shifts that they've worked plus 1. So if you're working a 4-day week, they'll always get full shifts. All right. As we said before, that leave that the employees go on must be unbroken, and it must include 4 weekends. And if a paid public holiday, PPH, a paid public holiday, falls in the leave period on a work day, then the leave must be extended accordingly. So if one looks at this year's calendar, we've got the Day of Reconciliation is on a Tuesday, Christmas Day is on a Thursday, Boxing Day or the Day of Goodwill is on a Friday, and New Year's Day is on a Thursday as well. So all of the public holidays fall this year on weekdays. Okay, so the leave period needs to be extended then by those 4 days. In other words, the working days leave that the employees take do not need to be taken in respect of any of those 4 public holidays. Right. So then leave enhancement pay, this is dealt with under clause 14 of the main agreement. Leave enhancement pay was formerly known as leave bonus. Many people still refer to it as the bonus, or leave bonus, or whatever the case is. It's exactly the same thing. It's known officially as leave enhancement pay, and it's calculated on 8.33%, which is exactly 1/12 of a year of actual earnings excluding allowances. So 8.33% is obviously a 13th check. It's 1 month's worth of earnings based on a 40-hour work week worked during the year. So if you look at the formula, very similar to the leave pay formula to begin with, the normal weekly wage rate. Then you multiply that by 52 weeks. Obviously, that gives you a year's worth of wages. Multiplied by 8.33% or 1/12 gives you a month's worth of wages. And then that same fraction at the end multiplied by the number of shifts worked divided by 234. And the formula works in exactly the same way as the leave pay formula does in respect of proratering. So if you've got an employee, that same employee who joined halfway through the year, you would take his normal weekly wage rate multiplied by 52 weeks multiplied by 8.33% will give you a month's worth of wages, multiplied by 117 over 234 is a half, so you'll get half a month's worth of leave enhancement pay or bonus. Okay, so there again, you don't interfere or change the normal weekly wage rate or the 52 weeks or the 8.33%. You simply put in the number of shifts that employee has accumulated, and that does the proratering in terms of the calculation for you. Okay. There are obviously other ways to do these calculations. We get a lot of phone calls at this time of the year where companies are working out employees' leave pay and leave enhancement pay, and they say, well, this is how I've worked it out. Is that correct, etc. Well, obviously, as long as you get to the right answer, it doesn't really matter how you got there. So there obviously will be different ways to calculate this, but make sure that whatever answer your payroll system or whatever you're using to work out leave pay and leave enhancement pay, make sure that you can check it, manually, if you will, by using this formula. And as long as you get to the same answer, then really it doesn't matter how it's been calculated, as long as it's correct. Now, ordinarily, the deadline for companies that need relief or exemption from paying leave enhancement pay is the 31st of October. we'll deal with this in a slide. I think it might be the next slide with what happens now that the main agreement hasn't been extended. But the usual leave enhancement pay exemption deadline is the 31st of October, and obviously that's passed. So we'll look at exemptions in a moment. So the payments of leave enhancement pay or LEP or bonuses, the obligation to pay leave enhancement pay potentially arises from three sources. Obviously, the main agreement, because that talks about leave enhancement pay. It's obligatory in terms of the main agreement, but also your contracts of employment and any past precedent that may have been set. So even though the main agreement isn't binding at the moment, if you are in a situation where you're not able to pay out leave pay or leave enhancement pay, if you're not in a position to pay out leave enhancement pay and you're wondering, what to do, you aren't under any obligation in terms of the main agreement because the main agreement hasn't been gazetted and extended. So therefore, the obvious conclusion to arrive at is, well, if the main agreement doesn't bind me, then I don't have to pay leave enhancement pay, and off we go. I would just caution you just to check your contracts of employment in case there's any reference made to leave enhancement pay directly in the contracts of employment. If there isn't, then it's far easier. And also, obviously, just bear in mind what the past precedent has been with your employees and what they'll be expecting. But at the moment, there is no main agreement in the industry or for the industry. There is simply a parties only agreement which hasn't yet been extended, as we explained earlier. So if you are in a position to pay leave enhancement pay, obviously, you can go ahead and pay it. That's no problem. But if you can't, if you've had a bad year and you're worried about affording the leave enhancement pay, then our advice is to take the steps that we've got under point 2 there. Look at your contracts of employment for any reference to leave enhancement pay or bonuses. I haven't seen it happen yet, but I really do believe that the potential exists for employees, even though the main agreement hasn't been gazetted and extended, to look at their contracts and say, all right, well, the main agreement may not have been extended, but you're actually contractually bound to pay me leave enhancement pay because my contract says that in December I get paid leave enhancement pay or a bonus or whatever the case may be. Okay, your contract may also say, may also reference the main agreement. If it does that, then obviously in any particular situation where the main agreement isn't extended, then that wouldn't be binding either. So just look at your contracts of employment. If you're worried, then you can obviously send them through to us and we can have a look and advise you accordingly. But take that into consideration. If there's no reference to leave enhancement pay made in your contracts, then what you do is you consult with the employees, and if they are unionized, with the union officials, you explain the situation to them. You obviously be prepared to motivate with proof. We don't mean circulate your financial statements or anything like that, but you might have, for example, a presentation where you say, this is what's causing the difficulty, and this is why we're struggling, etc. Try and get an agreement with your staff. Obviously, if you get an agreement, that's first prize. But even if you don't get an agreement, just file minutes of those consultation meetings in the company files, so that if there's any question that arises about, did you consult over not paying leave enhancement pay, you'll have the proof and the evidence that you did in fact consult. You'll notice, any of you who've ever had to seek an exemption from leave enhancement pay, you'll notice that this is a very similar provision in terms of the steps that one would take to apply for an exemption. But because there is no main agreement in place at the moment, you don't have to fill out any official exemption application form, and you certainly don't need to submit any exemption application to the MEIBC. But we certainly do still recommend that you consult with your employees. You don't want to leave the situation too late either. We're getting very, very close now to the end of the year, and your employees very often will be counting on that money. Certainly a lot of the employees may even start to spend that money before they've received anything. And so you do want to tell them as soon as possible, what the situation is if they're not going to be getting leave enhancement pay, or they're not going to get full leave enhancement pay, whatever the case may be. Okay. What happens though if if reference is made to leave enhancement pay in your employment contract? So maybe you've got a clause in your employment contract that says that the company will pay out leave enhancement pay every year or every annual shutdown or whatever the case may be. There is still a way that you can get around paying leave enhancement pay if you have to, if you're not able to afford it, and that's by invoking Section 189 of the Labour Relations Act. So Section 189 of the Labour Relations Act is the section that deals with retrenchments, operational requirement dismissals, and there it says that any company that's contemplating having to retrench employees needs to consult with the affected employees and try and reach consensus on appropriate measures to avoid the retrenchments, to minimize the number of retrenchments, to change the timing of the retrenchments, and to mitigate the adverse effects of the retrenchments. And of course, those discussions include not paying leave enhancement pay. So what one could do if you are contractually bound and your employees are really not trying not to allow or support or the non-payment of leave enhancement pay. If the situation is bad enough where you feel that if I have to pay leave enhancement pay, it would jeopardize the company insofar as us being able to retain staff, we might have to look at a retrenchment, then you can always send out notice in terms of Section 189, call the guys together and say, guys, if I have to pay out leave enhancement pay, then I may well have to retrench employees. However, if we don't pay out leave enhancement pay, then we can avoid the retrenchment, and hopefully then the employees will support that, and you can get it done that way. Even if they don't support it, you don't need them to agree, as long as that is a viable and reasonable alternative to retrenchment. Certainly that's what the court would expect you to do. They would expect you to not pay leave enhancement pay so that you can keep the employees in employment. Okay. Just for interest's sake, even though the main agreement hasn't been extended, the exemption process, obviously does exist. It is there. It's designed to meet the requirements of Section 32 of the Labour Relations Act. What I mean by that is that you can't have an agreement extended to the rest of an industry if there isn't an exemption procedure built into that particular agreement or the arrangements of the council. So that's all in place at the Bargaining Council, but the agreement that has been entered into by SAEFA and the trade unions hasn't been adopted as an agreement of the council yet, for the reasons that I started the presentation with. So there's no extension request yet, and there certainly hasn't been any gazettal extension. So the council therefore doesn't have any jurisdiction to grant exemptions from the agreement. The council, if any non-party, including any SAEFA member, were to submit an exemption from leave enhancement pay or from the wage rates or whatever the case may be, the council is going to turn around and say, we can't grant you an exemption or relief from an agreement that doesn't bind you. Okay, so they don't have jurisdiction to do that, so therefore exemptions are not necessary. However, like I said, we do recommend that you still go through the consultation process with your employees to avoid any issues closer to the actual shutdown time. All right, folks, that's it in terms of the presentation. Hopefully we've covered everything that everything needed in terms of the annual shutdown arrangements. We've got the details up there, but I would like to now just open up the floor, I think, and deal with some questions. So let's just have a look what we've got here. Okay, so all right, so I see nobody's put any questions. Hopefully the functionality isn't the issue, and rather that I've been thorough. Oh, here we are. Yeah, ask some questions. Okay. So Annika, you say, can we pay the leave enhancement pay at a lesser percentage? Well, beg your pardon. Let's deal with this. My apologies, folks. Dog's going crazy here. Can we pay the leave enhancement pay at a lesser percentage? Well, you can. You can if that's what you need to do. You can pay the leave enhancement pay at a lesser percentage simply because the main agreement isn't binding on you. So you can do that, or you can pay half a bonus or a percentage of the bonus. That's really up to you. What you would do is follow that same procedure where you consult with your employees, you minute those consultations, you file those minutes, and then you pay out. Try and get an agreement if you can from the employees. Try and get them to understand. But even if you're not able to do that, as long as you've consulted in good faith and you've explained the reasoning, you can certainly then pay out that leave enhancement pay at a lesser percentage. All right. Yeah, that looks like it for the questions. Although, Philip, sorry, I see that you've got your hand up. Please go ahead.
Hi, Gordon. Thanks a lot. I just wanted to ask, I didn't see on that, in regards to maternity leave, do those shifts that they missed out on while they were on maternity, the ladies were on maternity leave, does that accrue towards leave pay and leave enhancement pay, or how does that work?
No, an employee who's on maternity leave doesn't accumulate shifts. The reason being that if she's claiming from the sick pay fund, which she should be doing if she's a scheduled employee, because they've got a fantastic benefit of 100% of the employee's wages for 6 months, the sick pay fund actually pays out the equivalent of the leave pay and leave enhancement pay. So the employer wouldn't continue to accumulate shifts. She would be paid out pro rata leave pay and leave enhancement pay upon proceeding on maternity leave, and then obviously when she gets back, she then continues to accumulate shifts. But during that period that she's actually on maternity leave, she doesn't lose out. It's just that the sick pay fund pays her out that equivalent rate that she would have otherwise earned. Okay, so no shifts there. All right. Don't see any other hands or any other questions. Charlene, I know that you had I think a list of questions that we've received from members.
Yes, just a couple of frequently asked questions that I thought we could go through. Must employers pay employees their leave pay and leave enhancement pay before the shutdown?
Yeah, so leave pay and leave enhancement pay is payable on the day that they proceed on leave, obviously, or before. Anything else you would need to get an agreement with your staff on. Okay, so I know that there have been a few cases recently where employees have actually requested that they be paid leave, or they be paid some of their leave enhancement pay or some of their leave pay, or whatever the case may be, at a later stage or when they come back in January. If there's those sorts of requests, then yes, it can be done, but by agreement. The main agreement actually requires, and the Basic Conditions of Employment Act for that matter, an employee to be paid out. I'm talking nonsense. The Basic Conditions wouldn't require this, but the main agreement requires the employees to be paid out their leave pay and leave enhancement pay on the day on which they proceed on annual leave.
And can essential employees work during the shutdown period?
Okay, so that's an interesting one. Preferably not. The courts have a very specific outlook in terms of leave. Okay, now I'm talking here about the 15 working days leave. I'm not talking about the additional week that your longer serving employees qualify for. The courts have said that leave is not and shouldn't be used as like a savings account. So employees shouldn't be allowed to cash in the leave or be paid out the leave, because they want to see employees get adequate rest every year. Okay, so the courts are quite insistent on employees actually taking at least the 15 working days leave that they qualify for each year. Okay, that additional week, obviously, that can be paid out if needs be, but as far as possible, try not to have employees come in over the shutdown period, unless, of course, you allow those employees to work and then they take their leave at a later stage. That's fine, obviously, but try not to be in a situation where you deny some of the employees, even if they agree to it. It's still quite risky, because the Department of Labour or the Labour Court certainly would say the employees have to actually take that annual leave. So if you do want to observe a shorter sort of shutdown period, or if you want to do some maintenance work, etc., over the shutdown period, then there's a couple of things that you can consider. Maybe having two teams. One team works later into December and then comes back later. One team goes off earlier and comes back earlier. Or, as I say, you can have some essential workers come in, but they must then be credited with that leave and they must take that leave. And hopefully, shortly after they've performed that work, maybe in January or February or something like that, perhaps in Easter around that time as well.
Okay, should the MEIBC regional office then be notified in such instances if there are essential employees working?
No, you don't want to be doing it. If you are having essential employees work over annual shutdown, and then you're going to give them that time off, yes, then there's no harm in notifying the bargaining council. It's always good to do that, because then they know if there's an inspection, then you can say, well, we did notify you, you were aware of it. So yeah, best to notify them, so long as those employees are taking their minimum allotment in terms of annual leave.
Okay, and thanks, Gordon. And the additional 4th week leave, when does it kick in? I know it's after the 4th year of service, but say, for example, an employee started at a company in June of 2022 and you received pro rata leave pay at the end of 2022. So 2025 now would be his 4th December at the company. Would he now qualify, or would he qualify next year?
No, any qualifies after he's completed 4 years service. So if it was June 2022, June 23, June 24, June 25, he's only done 3 years. It'll only be June 26 where he completes his 4th year. That's when he'll qualify for an additional week's leave.
Okay.
For completed years service, not the 4th time of going on annual leave.
Okay, thanks, Gordon. And with regards to short time, say, for example, we have employees working, but 3 days a week, but not 24 hours. They only work, say, 22 hours during the week. How many shifts would they then qualify for that week?
My view would be 3 shifts for that week, because they should be granted a shift for every day that they work. But if I understand the question correctly, you're saying that they're working less than a full shift on each day.
Yes.
Yeah, then there's a couple of ways that you could interpret the agreement. The correct interpretation of the agreement is that 1 shift is exactly 1/5 of a full working week. So if the full working week is 40 hours, 1/5 of that is 8 hours. So you would have every right to interpret that to say that an employee qualifies for a shift after having worked 8 hours. Okay, so if let's say they're working 4 hours per day, you could grant 1 shift over 2 days, because only after the 2nd day would they have worked 8 hours. But it's up to you. That would be a very strict interpretation of the main agreement. Correct, but very strict. Otherwise, you could say, well, as long as an employee works, irrespective of the amount of hours, they would get a shift. So generally, there's 3 approaches with shift, the granting of shifts with different companies. A lot of companies will grant a shift the minute you arrive at work. So as long as you've been at work, you've clocked in, you get a shift. Other companies will say, no, it's only after 8 hours, after completing 8 hours, that you get a shift. And then some companies split the difference and they say, well, as long as you're here for half the day at least, then we'll grant you a shift. So be consistent in terms of your application there. You could use any one of those approaches. I think that during periods of short time, it is a very, very difficult time for everyone, obviously, but with the employees as well. So maybe in the interest of fairness, would be best to give employees a shift for every day that they actually work, even if it's not a full 8 hours.
Okay. And Gordon, you have mentioned the public holidays that are applicable during the shutdown period, those 4 days.
Yeah.
And that the leave should be extended by those 4 days, the 15 days, then the employees would be entitled to 19 days. If the company doesn't want to close for 19 days, they only want to close for the 15 days, what should they do? Can they pay the employees out if they don't want to pay the employees out for the 4 days?
You can't. No, you can't. You've got to let the employees take their 15 days annual leave. So
the extra 4 days.
Yeah. Because they've got to take 15 working days. So those 4 public holidays are not counted as working days. So if you were to close for 15 days, including the public holidays, and someone were to complain, the Department of Labour will say you haven't given these employees their minimum leave requirements. They have not been on leave. They have not received adequate rest, etc. It needs to be 15 working days. So there maybe look at 2 teams and then stagger when they go off on leave, so that there'd be an overlap. You could shut down for 2 weeks. You'd have a smaller team, the week before and the week after the shutdown, but still that is a way that you can shorten your shutdown period. Or, as I said, strictly speaking, you're not really allowed to do this in terms of the main agreement, but because the main agreement isn't binding at the moment, you could shut down for a shorter period, as long as the employees can then take their leave at a later stage. So you could say, for example, have employees take 10 days, or what would it be, 11 days if you want to include the public holidays, as long as you grant them then those 4 days, perhaps over Easter or something like that, then you've at least allowed them to take all of their leave, even if it is at a later stage. That would be fine too.
All right, thanks, Gordon. I think that's it from my side. Are there any more questions from the members?
Doesn't look like anybody's written anything in the chat, but obviously we can open the floor if there are any other questions that anybody would like to raise. Now's your chance. Okay. Doesn't look like it, so I won't then keep you unnecessarily. So the last thing then from me is to say thanks very much for joining us this afternoon. Hopefully we've answered all your questions. If you do have questions that you'd prefer just to ask, offline or after this this presentation, obviously you can send us an email or give us a shout telephonically, however suits you, and we'll happily assist. All right. Otherwise, if we don't speak again, have a really well-deserved break. Keep safe. If you are traveling, travel safe. Really use the time to rest and recuperate. And hopefully we can come back for a really successful 2026. All right. Thanks very much, everybody. Really appreciate your attendance this afternoon. Thanks so much for coming. Nicole, is that a hand? Oh, okay. All right. Thanks very much, everybody. Have a good evening. Cheers.
Thanks all. Goodbye.